Welcome back, everyone. My name is Michael LeBlanc, Director and Senior Portfolio Manager at Canaccord Genuity Wealth Management, and you are listening to MikeOnMoney.com, where every week we dive into different topics to help you with your personal finances, strategies, and financial planning. This week we're going to be talking about probably the most boring part or depressing part of financial planning, which is wills, power of attorneys, and representation agreements, which make a big part of plans. Or protecting your plans, especially when it comes to estate planning. I'm going to start with the very, very basics, and I'm going to move into the more advanced of when you want to use these, how you want to use these, things to be careful of, and just kind of the overall strategy of how they fit into that. So before we get started, though, just pointing out, I'm not a lawyer. I'm a portfolio manager and advisor. I've had a lot of experience working with partners, so this information from my years of experience and working with lawyers and partners over the years. But as always, anything you hear on here is for educational purposes. Do your own due diligence, do your own, or talk to a professional before implementing any of these strategies to make sure that they fit in are appropriate for your situation. As always, you can come visit us at MikeOnMoney.com, where you can reach us. Or give us a call, send us an email. We're happy to answer any of your questions on that as well. So let's dive into the three main documents that we're going to talk about today. So wills. Obviously, most people are familiar with a will, your last will and testament. So this is who and what you're going to leave your possessions to. Then we also have the power of attorney document. The power of attorney document is almost more powerful than the will, although not less vital. The will is vital, and we'll cover that. But the power of attorney, so that's while you're alive. So that's someone you've assigned to be your representative. So they have the power to act as you from a financial perspective. And of course, the representation agreement, sometimes called a living will, but that's the decision maker to your health decisions, right? So anything to do with the hospitals and doctors, and those exist where you assign. It can be the same person as the power of attorney. It can be different, but you're going to assign someone who's going to be able to make medical decisions on your behalf. Should you not be able to make those, depending on what might be going on. So let's start with the will, or the first step in all this. When to have one and why to have one. Well, throughout your lifetime, there's going to be a lot of different reasons why you want to have one. But let's start with the when. So a will deals with everything that's in your estate. So everything you own, right? So it tells the courts, it tells your executor. So you name an executor in there, and the executor is the person who's going to exercise that will. So they're going to take it usually to probate court, sometimes not, depending on the size of the estate. But they're the ones that are going to be able to take it to where the money or assets are held, and be able to pass those assets or that money on to the beneficiaries. So the people you've named in there, as to who should get what and how much. So the first decision you have to make when you're looking at a will is an executor. But let's go back to the why and when. Well, remember, it's dealing with assets. So when should you have one? Well, when you start to accumulate assets. So as soon as you start to build savings or assets, like purchasing a home, or you even have a share in a home, perhaps you're a co-owner, well worth getting a will at that point. Now, some assets you're going to accumulate early on, you might not need a will. So for example, RSPs, tax-free savings account, or TFSAs, they both have beneficiary designations. So that means if something happens to you, whoever you named as a beneficiary, it will automatically pass over to them. There's no need for a will. It actually bypasses the will, but that's a whole other conversation and rule we can talk about. But so you might not need it right away. So if all you've got as far as assets is some RSPs and some tax-free savings accounts, then you can use your beneficiary designation to bypass. The other things you might start off with is, for example, if you buy a joint property, so your first home with your partner, and it's in joint with right of survivorship, or joint name usually it's called, that also passes by that joint with right of survivorship status. So it bypasses automatically to the survivor. Not really, you don't really need a will, and you don't need to probate those assets. So not always necessary when you first get those assets, but as you start to accumulate, it's well worthwhile to put the will in place. You start to get in cars, or you start to have investment accounts outside those tax-free savings account or RSPs where you cannot have a beneficiary designation. You can own them in joint. Not everyone does, but you can. But you can definitely assign things through your will. And maybe you want to go to some of those assets to go to kids or other things, grandkids along the way. So well worth looking at a will when you've got assets to deal with. Something that's going to go through the estate, meaning that if something like were to happen to you, the assets are going to be distributed to one person or multiple people, and it's well worth having a will in place. A real important time to start to put a will into place as well is when you start a family, because one aspect of the will is to name a guardian. So what happens if something happens to you and your partner or your spouse, that the children, who are going to raise the children, that decision is made in the will. So you assign a guardian. Obviously the law, just like choosing an executor, you should put a lot of thought into that guardian. It's not always the most obvious person. You got to think about, where the kids would be raised, what the household's like, as far as religious beliefs. Is that the environment, that the schooling, is that what you envision for your children? Maybe it's someone else. I talk to that person. Obviously, you don't want the kids just to be dropped off at the door. So a lot of communication with the family when you're preparing your will. Who's going to be the executor? The executor should be someone, and it could be joint executors. You can have more than one, but it should be someone in the province that you're living in, if you can. Also be cautious of their age. If you're higher in age and you're naming a friend who's also higher in age, there is some running around to do in process and probating the will and getting all the work done. Maybe they're not up to it, maybe they are, but things to consider. Obviously someone who's got a little bit of experience handling these types of matters, or at least a proficient in these types of matters, and have the time to do it, because it is a bit of time to get out there and probate the will. So really important to put some thought into that, not just kind of who gets what. That's almost the easier part. Who's going to be your executor, most important part. Who might look after the family if something happens to both of you at the same time, or you're both injured and or one of you is injured and the other one's not, and make sure you have those details in there. Also, in your will, consider if you're in a second marriage situation and two sets of kids, it gets a lot more complicated. Definitely give us a call if you have any questions about that. There are some simple things you can put in the will to make that streamline better and make it smoother, depending on what you want to achieve. But that's a more complicated conversation. So let's talk about power of attorneys. Power of attorney is the one while you're still alive. So the power of attorney is the document that says someone else can act as you from a financial perspective. So they can make investment decisions, they can pay bills, they can access cash in your accounts. And of course, the idea there is if for some reason you're medically unable, whether temporarily or permanently, they're able to pay the bills, make choices for you financially in your best interest. So these are, I mentioned at the beginning, almost more important, and sometimes because, from a percentage perspective, more and more people are actually ending up at some point in their life requiring someone to act on their behalf or to have that financial ability. And don't think your spouse is automatically a power of attorney, because they're not. If there's accounts and joint names, 100% they can act on your behalf without a power of attorney, because those assets are joint. However, if it's solely in your name or they have the account solely in their name, you cannot act on their behalf, even if all the intent is good. You're not able to actually transact, say, in their RSP accounts or withdraw from their personal accounts without that power of attorney document. So well worth having a power of attorney named. It doesn't have to be activated or used on a daily basis. It's there in case of emergency, in case something happens. And even these days, of course, we're in the middle of the pandemic. If you have a power of attorney, someone was here and you got caught out of country, and there was things to be done for you here, they could use that power of attorney to make sure, bills are paid or whatever might have to, access an account to pay a car insurance or a property tax or anything of that sort. They can actually act on your behalf. So again, a very handy document to have in place. The representation agreement, not as popular with as many people, just from my experience. It is something to consider. Obviously, we're living longer and there are more medical decisions to be made. The longer we go, health does start to fail a little bit as we move along. So the representation agreement, again, it can be the same person as your power of attorney, it can be the same person as your executor, or it can be someone completely different, but it's someone you're going to name who's going to make final decisions based on your medical requirements. Now, don't worry, if you trip and sprain an ankle, they can't say pull the plug. Obviously, doctors have some say in this matter, but it does come down to life-saving treatment, DNRs, and things like that you might want to express your wishes to. Obviously, your representation person, your representative. What wishes, what measures you want to take in the event of health issues or an accident. But that person that can come in and make those decisions. Now, all these things combined create part of your estate plan, right? So you have your will that's going to deal with the estate that you might want to transfer on. You have your power of attorney who's going to help you along the way should you not be able to, and your representation or representative for health who's going to be there to assist you with those decisions or assist the family to get through those decisions should that be an issue along the way. Now, all these things, they don't expire. You don't have to worry about them. We do recommend you read them about every 5 years just to make sure nothing's changed that requires an update. You can't just scribble on a will saying, oh, by the way, I bought another house, or sold that car, here's a new car. You just can't, they have to be updated properly. Your power of attorneys, I mentioned, they might get older, they might move out of province, all things to consider. And when I mention out of province, especially out of country, we do have different rules by province, and we have different rules certainly by countries. So, if your executor or power of attorney is living in the United States, that's really going to complicate things. If that's your only choice, it's fine. There's ways to deal with that. But make sure you're expressing proper advice around how to do that in advance of doing up the documentations. But if you read them every 3 to 5 years, everything's fine. There's no update to be done. Put them back. A lot of people keep in the safety deposit boxes. Some people use somewhere safe in their files. But do double check them. If there is something that should be updated, definitely go update them. So, if you're reading through them and you've named, guardians for your 28-year-old kids, maybe it's time to do an update. It's time to take a look at the assets, because you don't want to cause any confusion down the road. Wills can be challenged in court certainly here in British Columbia and in Ontario. We have an act called the Wills Variation Act that allows people to challenge your wishes in there. So the clearer you are, and the more updated it is, obviously it communicates to the courts, these are your current wishes and these are your final wishes. So less chance of them being modified. There are ways to protect yourself around that. There's a simple trust you can use called alter ego trust, or partners trust if it's a couple. If you're over 65, you can use these. They replace a will, but they basically do the same things, but because they're a trust, they're not susceptible to the Wills Variation Act. So there are some things you can do to avoid that. Can also avoid probate. there are fees to probate. So just to touch on that, a lot of people worry about taxes. So you can gift money to beneficiaries in Canada with no taxation. Of course, if you sell something to give it to them, you might have capital gains for yourself, but the money you give to them is not taxed. Only anything they do with that money, if they grow it further after they get it, they would be taxed on that growth. You also, with estates, anything you will to someone, either by beneficiary or through your will, no tax once they get it, but your estate would pay any capital gains or final taxes on it. There is, however, probate fee. So there is a fee for the court to, certify that, yes, those are the correct beneficiaries. And yes, that's your proper will, and it is a legal will. A lot of people take a lot of steps to try to avoid probate fees, and in some cases, it's well worth it. You can save, $50,000 or $100,000. All depends on the size of the estate. But a lot of times, people will go spend $25,000 to save $10,000 in probate fees. So again, get proper advice. Understand, what the savings are of any steps you take to really offset what the end cost might be to the estate by going through probate, because it's not an evil thing. It's not really high tax like you could see in the U.S. depending on your situation down there. So in Canada, pretty easy, but definitely worthwhile having those documents. If you die without a will, it just doesn't go to your spouse, for example. It gets split up between children, spouse, sibling. There's an equation that is used. So definitely have a will in place. Make sure that it goes to who you want, and then again, use those beneficiaries as much as possible, because those are efficient ways of doing it as well. So with that, I'm going to wrap this up. I know it's a depressing topic, but springtime seems to be a time everybody turns to estate planning and these types of topics. So I wanted to cover it off and give you some thoughts around that. Do give some thought to reading yours, or if you don't have one in place, get out there and get one. But with that, thank you, everyone. Again, visit us at mikeonmoney.com, where you can find all our other educational videos. Reminder, Tuesdays at noon, we do a live market update where we cover everything off that happened last week, what's happened this week in the markets. And also this week, we're going to be talking about ESG, or ethical and socially responsible investing, and what new things we're seeing develop in that arena. You can watch our videos and also our podcast. You can go to catch us on all the main podcast streaming services. You'll be able to find us on there at mikeonmoney.com. So with that, thanks for everyone. Talk to you again soon, and have yourself a great